Tēnā koutou katoa. It's a great pleasure to be asked to provide an update from Australia focusing on public law developments associated with COVID-19. I'd like to begin by acknowledging the traditional custodians of the land upon which I stand, the Turrbal and Yagua peoples, and acknowledge that these lands have always been places of learning. As Australia is a federal state, the response to COVID-19 in Australia from the Commonwealth and state territorial governments has been one of collaboration as well as contestation, both in terms of constitutional powers and politically. Due to limited time, I'm focusing on describing the constitutional powers of the Commonwealth and examining two significant cases that challenged the exercise of public health powers by two Australian states. The Commonwealth has somewhat limited constitutional powers to manage COVID under the Commonwealth of Australia Constitution Act 1901. Its primary powers are its immigration and emigration powers under Section 51(27), which it used to institute strict international border requirements on Australian citizens and residents and on would-be visitors to Australia. Under its health and welfare powers, which is Section 51(23) and 23A, it introduced the JobKeeper subsidy to sustain employment during periods of lockdown and increased, albeit temporarily, job seeker payments, that's unemployment, sickness, etc. benefits. Under these powers, it's also responsible for the management of most of the aged care sector. The Royal Commission into Aged Care has critiqued the Commonwealth for its ineffectual use of its powers, particularly during the second wave in Victoria, when there were a large number of deaths in aged care. Under its defence powers, Section 51(6) of the Constitution, the Commonwealth may provide, on request of the states and territories, Defence Force members to support the activities of the states and territories. In this context, this is internal border controls, hotel quarantine security, and the like. Under its trade and commerce powers, Section 51(1), it is responsible for the licensing of vaccines. It also has specific power in respect of in respect of quarantine, which is under Section 51(9). But interestingly, it has chosen not to exercise this power and has left the responsibility for quarantine with each individual state and territory. So the responsibility for the management of COVID largely sits with the states and territory governments. Despite the instigation by the Commonwealth of a national cabinet, which includes all the premiers from each state and territory, there is fragmentation on perceptions among this group about how best to manage COVID in terms of issues such as whether internal border closures are warranted, definitions of hotspots, and whether we should be aiming for a suppression versus elimination strategy. However, the Australian responses have been driven by scientific advice. I'm now going to focus on two cases that challenge public health directions issued in Western Australia and Victoria. The Palmer case challenged on constitutional grounds the closure of the Western Australian internal borders to travellers from other Australian states and territories without advance permission from the Minister and without a period of hotel-based quarantine. The challenge was pursuant to the Section 92 Free Trade, Commerce and Intercourse Constitutional Guarantee. The Federal Court made findings of fact before the legal questions were remitted to the High Court of Australia for determination. One argument advanced by the plaintiff was that a suite of other public health law measures could have been used, and therefore the border ban was disproportionate to the risk of transmission of the virus from travellers. Rangaya J of the Federal Court accepted that public health decision-making about restrictions to be imposed upon the public, quote, requires a precautionary approach, given the uncertainties and the potentially severe consequences of an outbreak, end quote. Further, and again I quote, although the probability that a particular health risk will manifest may be small, if its consequences are potentially catastrophic, a precautionary approach is required. This means, from a purely public health law perspective, all reasonable and effective measures to mitigate that risk should ideally be put in place, end quote. The High Court subsequently found no violation of Section 92, and therefore the border restrictions were constitutional. In Victoria, a judicial review and human rights challenge was brought against a curfew ordered under public health directions at the height of the second wave in Victoria. In Loyallo, the plaintiff claimed that the curfew order violated the right of movement and the right to liberty and security of the person under the Victorian Charter of Human Rights and Responsibilities. Janine J. held that the right to liberty and security was not engaged, citing Bell J. and Ree Craig. Quote, the difference between deprivation of liberty and a restriction on freedom of movement is one of degree of intensity, not one of nature or substance, end quote. Janine J. also noted that the curfew order applied to the population as a whole, whereas the right to liberty and security is usually engaged by the circumstances of a particular individual in respect of criminal activity or unlawful entry into a country. Janine J. also noted in respect of the plaintiff's claim that the curfew was unreasonable, irrational, or illogical. Quote, there was a public health purpose for the directions, and she, the decision maker, considered it necessary to continue the curfew as part of a package of restrictions in response to the COVID-19 pandemic to eliminate or reduce the risk to public health. When different opinions are reasonably open, a decision to adopt one of them cannot be described as irrational or illogical, end quote. The claim that the decision by the decision maker was made at the direction or behest of the Premier was also dismissed by the court. Thus, the Australian case law emphasises places emphasis on proportionality and on a precautionary approach to the risks associated with COVID. Thank you.